First, I would like to review all information given by the case. In the case of the covered entity healthcare provider, the issue safeguards and minimum necessary. In the plaintiffs, there are several plaintiffs, and the defendant is AU Bright Smiles Dental. The original investigation confirmed that AU Bright Smiles Dental flagged some of their medical records with a red sticker with the words AIDS on the outside cover, and that the records were handled in a way that allowed other patients to visibly see the sticker in the front lobby without necessary permission to view that information. It is my duty as a jury member to find in favor of the plaintiffs claiming breach of confidentiality by the defendant, AU Bright Smiles Dental. It was stated during the initial investigation that the sticker adorning the outside of the plaintiff's medical records notified individuals that are not authorized to know the client's information about their medical status, i.e., that they were either HIV or AIDS positive. Even if the client's name might not have been fully visible to a passerby, the diagnosis was clearly visible and understandable to all who viewed it. If a particular file would have been accessed in the front office, visible to other patients, they would then know that the respective client whose file was just pulled was AIDS positive. It is generally understood that when a person becomes a patient at any healthcare organization, all of their private information will be kept confidential and only released on a need-to-know basis. Even in the United Kingdom, the General Medical Council states, patients have a right to expect that information about them will be held in confidence by their doctors, and that confidentiality is central to the trust between doctors and their patients. To keep a client or patient's information confidential, it is also a way for the medical practice to respect a patient's autonomy. The patient's right to decide what personal information will be shared with other people and which people to share that private information with. There is an unspoken understanding. There's also a confidentiality or a disclosure agreement signed by the patient limiting the release of private information. There is also a legal and professional obligation to protect a patient's information, and since there has been a breach in that privacy, there should also be compensation for undue harm received by the defendant's negligence. The Health Insurance Portability and Accountability Act, established in 1996 and finalized legislation for patient privacy in April of 2000, is very explicit in the direction of patient information, as well as consequences for breaches of confidentiality. I find in favor of the plaintiffs and award civil penalties for breach of confidentiality by AU Bright Smiles, caused by unknowing violation of HIPAA privacy regulations. The plaintiff is awarded a financial compensation that will be designated by the Secretary of the Department of Health of a minimum of $100 per violation and a maximum of $50,000 per violation, with an annual maximum of $1.5 million. The defendant will also have a period of 30 days, as regulated by HIPAA Code of Ethical Conduct regarding confidentiality, to make the appropriate changes to ensure the safety, confidentiality, and anonymity of patient information from the public or the organization will be reassessed and find a larger financial stipulation due to knowingly negligent behaviors regarding client information as described by the Department of Justice.